Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's Computer Magazine each month in 2012. This podcast is part 4 of our series. In the last podcast, we discussed privacy and data security. In this podcast, we will cover the initial steps to take if you're sued for patent infringement. Joining me today for this podcast is my colleague Brian Murphy. Brian is a partner in the New York office of Edwards Wildman Palmer. Welcome, Brian.
Thanks, Brian. It's a pleasure to join you today for the podcast.
Brian, finding out that you've been sued for patent infringement is usually an unpleasant experience. Typically, it means that you're about to spend a lot of time and money defending yourself. Companies that are sued for patent infringement sometimes have trouble getting organized to respond to the suit, and that can introduce delays and additional costs. One part of the lawsuit that presents many challenges to companies is early on when the company, as U.S. litigation rules require, must preserve and collect documents relevant to the suit. Companies usually have concerns about this when they realize that the documents could comprise hundreds of thousands or even millions of pages of material, both in electronic and hard copy form. So, what's a company to do to keep this manageable?
First and foremost, Brian, the defendant company that's been sued needs to understand and frame the potential economic and strategic impact of the case on its business. For example, is this a nuisance suit where the company is a bit player among many defendants caught in the plaintiff's net? Or is this likely to be something very different, a ferocious struggle with a direct competitor who is striking at the heart of the company's business by filing the lawsuit? Is there a risk of an injunction that could shut down all or part of the defendant's business? After all, the patent right is the right to exclude others from making, using, selling, and importing the patented invention. So an injunction must be assessed. What are the potential damages if an infringement were to be found? Does the company have any of its own patents that it can assert against the plaintiff's products or processes in what we call a counterclaim? What are the realistic options for resolving the case? So answering these questions and performing this type of economic and strategic assessment quickly but carefully with input from the interested internal constituents and experienced patent counsel will shape the best possible defense strategy. And of course, this will guide the types of documents that you need to gather and organize for the case. So one of the first things a defendant in a patent infringement lawsuit needs to do is implement what we call a litigation hold. And this is the purpose of this litigation hold memorandum is to preserve materials that relate to the suit. When a company is sued for infringement, the company's lawyers typically prepare a list of categories of documents and other things that are relevant, and then ask the appropriate people in the company, usually including IT personnel, to help ensure the preservation of the relevant material. So in other words, steps are taken to prevent relevant documents and other material from being inadvertently deleted or destroyed now that a lawsuit has been instituted. And that's why we call it a litigation hold memorandum. Some typical categories of this litigation hold include research and development information, such as laboratory notebooks, product development reports and product test results, sales figures, marketing documents, and even previously performed analyses of the patents, if they exist. However, the amount of material included in these categories can and usually does increase tremendously when you consider that emails which discuss these topics must also be included in the litigation hold. Added to that, the materials that could be stored on, for example, an individual employee's computer hard drive, flash drives, as well as on mobile devices, iPads, and the like. All of this electronic information must be preserved and potentially searched in conjunction with the lawsuit. So in short order, you can see, Brian, how this process of preserving and collecting documents can rapidly escalate into a complex, time-consuming, and far-reaching effort that needs to be well managed.
Clearly, then, the defendant company needs to get control of this right away.
That's right. And there are a couple of ways to handle this. First, you need to step back and identify the specific individuals in the company who are most likely to have the relevant materials. And what I've found in my experience is it's most helpful to assign a point person to be assigned the task of managing the individuals in the company who have the relevant materials. So unless the company is small, that probably means, if well managed, that you can avoid collecting materials from every employee in the company and paring down the list of people to collect from, the so-called custodians, can greatly simplify the process and reduce the likelihood that you'll be collecting irrelevant information. Another way to handle it, and particularly if there is a large volume of material from a limited number of custodians, is to search electronically each custodian's materials using a keyword search. Only those materials that include one or more of the keywords are selected. And of course, this is easier said than done because the identification of the proper keywords is a complex process with significant legal ramifications. Consequently, preparing a list of keywords and doing an electronic search are tasks that are typically left to the lawyers in consultation with the IT professionals. So one of the best ways a company can manage preservation and collection of documents in a lawsuit is by having a document retention policy in place before the litigation begins.
That makes sense. What are some of the attributes of an effective document retention policy?
Well, there are many different types of document retention policies, Brian, and of course each company is different, but there are certain common basics that you usually see, right? One goal, of course, for technology companies is to ensure that the important documents are preserved while at the same time making a value judgment of less important documents that can be disposed of on a specified regular schedule. So, for example, a company's policy should work to preserve laboratory notebooks and development records of the company's inventions and other intellectual property. Typically, these types of documents are held in perpetuity without any instruction for destruction or deletion. General emails, however, are the type of thing that could be permanently discarded after a short period of time, say every 6 or 12 months, depending on the circumstances. I do want to stress, however, that these are just examples. A document retention policy needs to be carefully thought out to be sure that it complies with both applicable law and the company's practical internal needs. And also, once the company creates the document retention policy, it's imperative that the company act to ensure compliance on a steady, regular basis.
So far, we've been talking about what happens after a patent owner files an infringement lawsuit against a company in U.S. federal district court. As you know, in certain instances, it's also possible to file a complaint of patent infringement with the U.S. International Trade Commission, or ITC. Can you speak about that?
Sure, Brian. The ITC, or International Trade Commission, is an administrative agency with jurisdiction over goods that are imported into the United States through customs ports. The ITC gets involved in a patent case when a U.S. industry is threatened by the importation of goods that infringe a U.S. patent. Examples of these are typical in the memory business: DRAMs, flash memories, EEPROMs, all of those types of electronic memory devices that are patent protected and imported into the United States in competition with the U.S. industry are the types of things that are often involved in ITC cases. So a patent owner can file a case with the ITC when the patent infringement that's alleged involves importation and injury to a United States industry. Otherwise, a patent owner would have to follow a more conventional path of filing the case in United States Federal District Court and not the ITC. A significant difference with ITC actions is that they proceed much more quickly compared to most cases filed in U.S. District Court. In fact, ITC actions by statute usually take 12 months or less, while district court actions, for example, can typically last 3 to 4 years. So when you're defending a patent infringement action in the ITC, in my experience, this requires what I refer to as a SWAT team approach. Companies defending themselves in ITC actions need to deal with the challenge of an extremely expedited schedule. Document production requests, responses to written interrogatories, all of the usual discovery demands are accelerated, typically with a 10-day response schedule, which is incredibly onerous and burdensome on the company. Virtually every task that a defendant must complete in a conventional patent infringement lawsuit now needs to be completed on a much compressed schedule. This usually means that only the strongest and most important issues get raised in the case, because there simply is not enough time to explore every issue in such a case. So it's imperative that a company who is responding to a complaint filed against it in the ITC not delay in any respect. The company needs to get its lawyers, both in-house attorneys, outside attorneys, as well as their business people and the knowledgeable custodians and fact witnesses involved right away. And as I said earlier, that initial strategic analysis, it's even more important to do it right away.
Let's talk about the other end of the spectrum, getting sued for infringement and then challenging the patent in other ways than through litigation. That sometimes has the effect of slowing down litigation, correct?
Yes, it sure does. When a company is sued for patent infringement in U.S. District Court, that defendant will typically allege in its answer that the patent asserted is invalid. So, for example, the defendant company may say that one or more of the claims in the patent are invalid because it was anticipated or obvious in view of what was described in the prior art. In other words, the claim being asserted describes something that already existed and was published well before the patent application was filed. So if a company being sued for infringement in district court has good arguments that the patent is invalid, it has the option of asking the U.S. Patent Office to review that patent and the arguments that the defendant would like to make. The Patent Office, particularly under the America Invents Act, the AIA, which is the new change to the U.S. patent laws, there are several administrative procedures where the Patent Office will conduct a review or re-examination of an issued patent. So one very practical and common strategy that defendants can follow is to try to apply to the Patent Office for a re-examination or review of the patent and try to convince the Patent Office that the patent that is at issue is invalid, and at the same time making a motion in the district court and asking the judge assigned to the case to suspend, or what we call stay the litigation, until the Patent Office review is complete. Now, if this strategy is executed early on in the case, many courts will agree to it, and in fact they will suspend or stay the litigation and allow the defendant to proceed in the Patent Office to see if the Patent Office will invalidate any of the claims or perhaps force them to be amended so that they have narrower coverage. And that's usually a lot cheaper than proceeding with a full-blown patent litigation in district court. And so it is a tried and true strategy, but it needs to be implemented fairly quickly so that the district court will stay or suspend the case.
Thanks, Brian, for giving us your thoughts on this. Because every situation is different, anyone confronted with a patent infringement lawsuit should act only after getting legal advice that's specific for that situation from a qualified attorney. We hope that you found this podcast helpful in understanding patent infringement cases. Stay tuned for our next installment in Computer Magazine, which will cover recognizing certain events where it's critical to get legal advice as soon as possible. Until next time, this is Brian Gaff
and Brian Murphy.
Feel free to contact us via email at bgaff@edwardswildman.com
or bmurphy@edwardswildman.com.
Thank you.